Next matter the court's going to take up, State of North Dakota versus Richard William Edders.
I'm disappointed that someone who was trusted to be a husband, a father, and a safe person in our home chose to cause harm instead. I'm disappointed that my children have to learn far too young what someone they should have been able to trust could betray that trust so completely. I also recognize that we share a child, and I believe that child should have the opportunity for whatever safe and appropriate relationship that with their father that may be possible. But maintaining that relationship cannot come at the expense of my other children or create an additional trauma and stress within our home. I also ask that the emotional safety of our shared child be considered in any contact or visitation involving his family or the people around him. I hope the sentence and the decision made moving forward reflect on the seriousness of what happened while allowing my children the safety and stability they need to heal and move forward.
Is there anything you would like the court to know in regard to sentence?
Welcome to Court and Case, where the law meets the facts. Get ready to dive deep.
Regard to sentencing specifically?
No.
Other than the portions you've just explained?
Just
Okay. Nothing further, Your Honor.
Mr. Murphy.
Thank you. This is the second time in your lifetime that your partner's arrest has resulted in you having total possession of the family home, correct?
I'm
no.
going to object on.
I didn't hear
know
I didn't hear the question, Mr. Murphy. Can you speak up, please?
Yeah, thank you. This is the second time your partner's arrest has resulted in you having total possession of the family home, correct?
No, this
I'm
is
going to
the
object.
first
on-
home
I'm
I've
going to
ever owned.
wait. I'm going to object. I know that the rules of evidence don't apply, but what in previous relationships has happened in a divorce has zero relevance in a case like today.
Your Honor, I think it holds a lot of
Stop.
relevance.
Mr. Murphy, it sounds like there's a relevance objection. The rules of evidence don't strictly apply, but they loosely apply. Can you tell me where you're going with this?
The investigation on this case never delved into background of the reporting side of the offense. This isn't the first time that this similar scenario has happened.
The states, can I respond to that?
No. I'm going to allow you to ask very limited questions about this, Mr. Murphy, because I find it of very limited probative value.
Basically, this isn't the first time, correct?
This is the first time. I've never owned a home before now. Or been on a loan ever before now.
No, that's not the question. The question was, it resulted in you having total possession of the family dwelling.
In like a divorce. So
No.
when I divorced my last person
No.
or
The
last
question,
ex,
the question was this. The arrest of your partner resulted in you having total possession of the family home.
that's never happened.
In Washington?
No.
Your spouse wasn't arrested and resulting in your possession of the home?
No.
Can you describe what happened out there?
I'm going to object
In
again.
Washington with my first husband or my second husband. Richard is my third.
Second husband.
I object.
My second husband
Stop. State your
moved out of
stop,
the.
Stop.
Sorry.
State your objection.
I'm going to renew the objection on relevance, even loose relevance. Whether she gets possession of a home because somebody is arrested, she answered the question. If this court's response was she has a very limited area of relevance in relation to that, I think that's been answered. What has happened in her previous marriages, I don't think is relevant today.
Mr. Murphy.
Motivation for as long a sentence as she can get if it results in her possession of the marital home.
What sentencing factor does it approach? What sentencing factor does it make more or less true?
I don't have that reference, Your Honor. It just goes to credibility, Your Honor.
All right, I think credibility has been addressed, so I'll sustain the objection. You can move along.
There was testimony that your daughter heard the phone calls between Richard and his daughter, correct?
In the beginning when he was arrested, correct.
And you've allowed her to hear those conversations?
Not since then.
Is that an accurate statement that you told the investigator that maybe you shouldn't talk like that either?
Your Honor, we had a trial on this case and she was cross-examined on, in essence, the same things. I don't think the trial court has completely eliminated all of the testimony from their memory, and I didn't intend on retrying the case today either. The cross-examination is related to the victim impact
Can
statement. That's what
I
we're here
read
for.
it?
Mr. Murphy?
This report is part of the PSI, Your Honor. I wouldn't have had access to any of this prior to today, or prior to receiving this from out of the PSI addendum, Your Honor.
I'm gonna object to that as well. It's a law enforcement report that he received in discovery. He absolutely received that before today.
Mr. Murphy, what's its relevance to sentencing?
One of the things he's being sentenced on, vocabulary in the household, disorderly conduct, talking about shaving, that type of stuff. It was noted in the testimony that that's just normal for the household.
That objection is sustained. Move along. Whether she did it to be clear for the record, justify Mr. Etter's conduct, which the court found to be beyond a reasonable doubt.
That's all I have, Your Honor.
There's only one person in this case responsible for criminal behavior, and that is the defendant. This case involves 3 separate victims, all of whom have been greatly affected by the defendant's choices in criminal behavior. These victims have something in common. Despite their age, and for 2 of them being siblings, they were all told by the defendant that they probably shouldn't tell anyone about what the defendant did to them. Why? Well, because he'd probably end up where he is today. Starting with the sexual assault charges, they're similar in that they come from the same day and event, but they're different in that they come from different victim perspectives. And they're also different because count 2 includes the defendant being a parent or guardian to the victim. As I said during trial, this wasn't a game of Candyland or Monopoly. This was deviant sexual crimes on repeat. The disorderly conduct of asking a child if she shaved, it included telling her that she had pretty feet, talking to the victim about her butt, talking to her about doing squats while she was working out in the garage, demonstrating an insinuation of oral sex while talking about watching her workout, telling her that she is, quote, his type, quote, and asking her if she shaves. The victim described these events in great detail during trial. The victim talked about these events happening in her kitchen, in her house, in rural locations while driving. All of these occurring in a place the victim was supposed to think of as home. There's no greater betrayal. That same standard applies to a step-parent. There's very few things more heinous than that, and the legislature seems to agree, as they have made this offense a Class A felony, the second highest level offense in our state. A trial in which the defendant couldn't even put his antisocial ways aside throughout the trial. A trial in which the defendant simply defined his behavior as, well, sometimes I just do stupid stuff or say stupid stuff. This conduct is not nearly as simple or as innocent as the defendant would like the court to perceive it. Antisocial isn't just an opinion of the state either, it's a diagnosis the defendant has. Psychological evaluators of the defendant have said it's concerning the defendant has completed sex offender treatment twice, but continues to deny, minimize, blame victims, avoid responsibility, and show poor insight and judgment regarding appropriate sexual boundaries. Quote, his statements are not suggestive of a rehabilitated offender. It's a pretty bold statement from an evaluator, but it is one that's been opined of the defendant in an opinion that was filed with the court. With this antisocial came, as expected, 0 genuine remorse for his actions. The defendant has an excuse for everything. Who do we blame this on? Well, first his wife. She didn't give him enough attention. In one comment, the evaluator noted, the defendant acknowledged having thought about women and teenage girls in a sexual manner, but then noted that sexual attraction can be normative per the researchers if it is not acted upon. Well, here, it's clearly been acted upon for 2 of the victims, and he has acted upon it in the past with his prior offenses as well. This is concerning. The defendant also doesn't believe he needs treatment, and he said he doesn't need it because it makes him feel like less of a person. Well, the defendant's sexual assaults and GSI and disorderly comments probably made the victims all feel like less of a person too, so perhaps it's time for the defendant to start thinking about someone other than himself. He also tells the evaluator that his wife, the judicial system, the police, and the victims are included on the list of people to blame for these offenses. On count 1, I'd ask the court to sentence the defendant to 20 years with the Department of Corrections, first to serve 10 years, credit for 355 days, no good time calculation based on Baker, 10 years of supervised probation, lifetime sex offender registration. On count 2, 5 years with the Department of Corrections, to run consecutive to count 1, first to serve 3 years, credit 355.
Let the punishment fit the crime. call a spade a spade. Horrible language that apparently the household got used to. People would say stuff, they would joke about stuff. It's in the report. Yeah, we used to joke around about that, and it wasn't until, later on that I kind of started going, that's really not sitting well with me. And even when she demonstrated the hug that he gave her from behind, she indicated that his hand was on her arm, and what grazed her chest was his forearm. Okay. So that's what got charged out as the GSI, because the legislature said in an aggressive manner, my teenage daughter and my teenage son, they have been difficult at times. They have been frustrating for me. They have not wanted to hug me. They have not wanted to acknowledge, my position as their parent. Have I hugged them when they didn't want me to? Absolutely. I don't believe for 1 second that the legislature intends that when you hug a teenager, when they don't want to be hugged in an aggressive manner, that you should be looking at 20 years in prison. We have murders, killings, multiple assaults that are getting sentenced far less than what Ms. Duffy is requesting in this case. It's up to you to decide an appropriate sentence, Your Honor. But 20 years on a hug on a teenager that doesn't want to be hugged looks to be excessive. Sex offender treatment, outpatient, inpatient, monitor him, whatever. He understands. He's looking at lifetime registration. He understands that. And he doesn't have a problem with that. He doesn't want to have anything to do with anybody at this point. He wants to go to his house in Ypsilanti, work his job, grow his garden, and stay away from everybody. That's what he wants to do. Putting him in jail for an extended period of time is going to solve nothing. The teaching on how to do dating or groping or whatever you want to call it, yeah, that's inappropriate. He wasn't doing it himself. He was having the two of them do it. That's not what I would do, Your Honor. But this isn't a 20-year sentence type of thing, Your Honor. The garbage talk, absolutely, it's garbage talk. Par for the course for the House, apparently, but that's disorderly conduct. We don't need to make a mountain out of a molehill. You want to give him 10 years of probation, that'll put him into his 50s. As far as incarceration, he's spent over a year at Barnes County, waiting trial, waiting sentence.
A lot of difficulty with this because what I have been accused of is not who I am. Ms. Duffy says I do not take responsibility for my actions. I have not been accountable for anything. From the moment I got the text message from my wife asking me what was going on, when law enforcement was involved, I readily went to them. I am an honest person, Your Honor. Back in 2013, I told the truth and convicted myself of my crimes. I have been telling the truth since day one, hour one, with this case. Ms. Duffy spins stories. She does not tell the truth. She does not use facts. She uses half-truths. I have seen it so many times, and I know I don't know everybody and their stories, but I have seen her do it so many times in this courtroom, Your Honor, and it is aggravating, to say the least. I am severely remorseful and regretful for what I have done. I pray that you'll have mercy on me as well. I am a man of God, and I am honest. And I'm tired of seeing the system fail people because of people like Ms. Duffy that spins everything and does not tell the whole factual truth. Yes, I ask people, or the victims, to not say anything to anyone because I felt utter shame and regret and embarrassment. And I'll wrap this up. It was not to hide anything from anyone. It was to give myself time to figure out what needed to be done and do it right. Unfortunately, the law became involved. Ms. Duffy became involved and has seemed to have a vendetta for me. I don't know where this stems from, Your Honor, but she seems to have a vendetta. And I pray for her as well.
It is concerning that you report to have completed sexual offense specific treatment twice, but continue to deny, minimize, blame victims, avoid responsibility, and show poor insight and judgment regarding appropriate sexual boundaries and your ability to maintain safe behavior with minors. The psychologists conclude his statements are not suggestive of a rehabilitated offender. Management of Mr. Etter's risk will require substantial amounts of further treatment. That's what the psychologist concluded. I can tell you that I was a defense attorney for a long time. I represented about 5,000 people. I represented a lot of people charged with sexual offenses. And I've seen a lot of these evaluations, both as a defense attorney and as a judge. That statement and that directness is rare. And because it's rare, it's concerning. Mr. Etter, you have a prior 2013 conviction for gross sexual imposition, 2 prior counts of corruption or solicitation of minors involving 3 teenage girls. In addition, you've got some minor financial and traffic offenses that the court doesn't weigh much in favor or against sentence. You were on supervised probation for 10 years, and that probation ended mere months before the conduct here happened. But I have concerns that that means that you were merely biding your time until that expired. Shaking your head no, but that's what it looks like when mere months after the fact, evidence was destroyed in the course of the investigation. Namely, a cell phone was factory reset after a search warrant for your cell phone was obtained. The record doesn't reflect that you caused that to have happened, but nevertheless, the result is the same. The evidence was destroyed before it could be searched. Throughout the process, even at sentencing, your argument wasn't, this is what I'm responsible for. It was Miss Duffy's a liar. And Miss Duffy abuses people. And it wasn't just a hug. Throughout your sentencing argument, you made several references to this was just a hug. It was incidental. It wasn't just a hug. It was a hug coupled with sexualized comments. I want to watch you work out.
I didn't make those comments, Your Honor. Those 2 specifically. The
Well,
other ones were taken out of context.
yeah. So again,
But
stop talking because this is where I'm talking, not you.
This is where the justice system has failed, Your Honor.
You need to be silent. Simulating oral sex to a 15-year-old girl.
Never did that, Your Honor.
Sir, again,
I have told the truth, Your Honor.
stop talking. That's what the court found to have been proven. That's what the testimony came out as. That's what the court found. On count 1, 20 years, the Department of Corrections and Rehabilitation. First serve 8. Balance suspended for a period of 10 years. 10 years supervised probation. Lifetime sexual offender registration. Count 2 involves the parental 5 years Department of Corrections and Rehabilitation. Count 2 also includes a minimum mandatory 5 to 10 supervised probation term. There is cases that allow the court to impose both a maximum jail sentence and a maximum probation term. The jail sentence of 5 years is to run consecutive to count 1. The probation term is to run concurrent with count 1.
Just for clarification, so count 2 and 3, all the probation's running concurrently with each other, I mean, correct?
So in total, the court sentence is 8 plus 5 to serve with 10 years of supervised probation to follow. And if he were to have been revoked during those 10 years, he would have a total of 12 years hanging over his head.
Understood.
Does that make sense, Mr. Murphy?
Clear?
All right. Anything that I missed, Mr. Murphy?
Don't believe so, Your Honor. Thank you.
With that, we're adjourned.
He walks into sentencing asking for mercy, but the judge is focused on everything that happened before this moment. The defendant is facing punishment for serious sexual offenses involving multiple victims, including conduct involving a teenage girl. Prosecutors point to his prior 2013 conviction, previous offenses involving teenage girls, and psychological evaluations questioning whether he has truly accepted responsibility. The defense argues that the conduct has been exaggerated and pushes for treatment instead of a lengthy prison term. The defendant then insists he's remorseful, says he has been truthful, and blames others for what happened. But the judge sees a troubling pattern. When the defendant tries to interrupt and dispute the court's findings, the judge cuts him off. Stop talking. The courtroom then reaches its most important moment, the sentence. The judge orders 8 years to serve, followed by 10 years of supervised probation, with another 5-year sentence running consecutively. Lifetime sex offender registration is also imposed. The hearing ends, but the consequences will follow him for years.